as the NAACP for the exact same goals as the NAACP are not protected, and it's illegal. Allied and Claiborne simply cannot be reconciled after Citizens United. Okay, they cannot be. The only conclusion somebody could draw is that Citizens United has overturned the Allied decision. So not only does AB 4 restrict speech based on the identity of the speaker, it only applies to unions. It also restricts speech based on the content of that speech. So think about it. In our case, we were accused of encouraging workers to withhold their labor, which of course we didn't do, which would violate Section 84. However, if we were accused of encouraging workers to work harder, that wouldn't violate Section 84. Therefore, the content of the speech, what the union is saying, a court's going to have to interpret that to determine whether or not it violates AB 4. That means it's content-based. It's also content-based in another way. Section AB 4 would not restrict a union to call for workers to go on strike in support of a primary labor dispute. So for a court to determine whether a union's call for a strike violates Section 84, the court's going to have to determine who was that aimed towards. Is the content of that message aimed towards workers who work for an employer who's part of a primary labor dispute or not? So they have to look at both what the union's asking and who the union is making a call to. It's clearly content-based, and as such, it's presumptively unconstitutional. Now, we do not have time. I mistimed how long this we're going to have, so we do not have time to talk about this, but I can assure you there are traditional interests the Supreme Court has given for why Section 84 doesn't violate the Constitution, the First Amendment. Every one of these justifications has been rejected by the same Supreme Court outside of the labor context, okay? So I can tell you that all of these compelling interests have only been accepted at this point for labor unions, and under Citizens United, that's not gonna fly. And we're also not gonna talk about this, but the law is also not narrowly valid. What folks who aren't lawyers and law students need to understand is, if something's subject to strict scrutiny, it's virtually impossible for it to be constitutional. And in fact, the Citizens United decision itself said there is no justification for blocking the political speech of a corporation, okay? There is no justification sufficient to do that. So that would clearly apply to unions as well. So that was the legal argument. Then we have this factual argument that we really didn't want to rely on, but that's how we're going to win the case probably. So even if AB 4 is constitutional, as I said, we did not call on anyone to withhold their labor. So factually, there's nothing here that approaches a violation of Section AB 4 in our resolution. As I said, it merely encourages, it endorses the BDS movement and encourages people to engage in it. And it really doesn't really call on any specific action. The allegations from Shahrat Hadin are completely absurd. They claim that although the resolution didn't call for anyone to strike, okay, so here's the nexus they have. Although the resolution, they admit, didn't call for anyone to strike, on our website, when we posted the resolution, we had links for people to get more information. One of those links did not link to anything that called for people to strike, but the organization we linked to had linked to another organization that 5 years earlier had called for workers to strike for 3 days. And that is how our members reading our resolution are going to say, let's go to that website, let's find out who they're associated with. We have to go on strike, the union said to go on strike. It's absurd, it's absolutely absurd.
Secondary link.
The allegations are bizarre, they're the result of tortured logic, and they're embarrassing. I mean, I was embarrassed for them, I have to be honest.
They don't care.
But you liked it.
I did like it. So, what's going on with the case now? Where are we? Where have we been? So when we first saw the charges, we did not take them seriously because they are so absurd. And we actually assumed that the NLRB was going to dismiss them out of hand, and we actually didn't. I was on vacation, I saw them, I was like, nothing was going to happen, we weren't going to have to do anything, so I thought. But I get back to the office, the board has called, and they want us to respond very, very quickly in a full way. Wow, Margo, we have to go look. Let's go look at what's this about. Let's go look at these charges. So we went back to our offices, and we looked carefully at the charges, and we did some research. We met, and No, we were right. The charges are completely absurd. And so Margot and I spent the next couple of days just making fun of these people. They deserve to be mocked. So we knew that the charges were ridiculous, but again, like I said, we knew this was a real opportunity to challenge Section 8B4 on political grounds, which, as I said, we think is a really good stepping stone to strike it down overall. And I think it will be struck down eventually overall, unless the court, is completely intellectually dishonest, which can happen. So in fact, we were so enamored with the idea of attacking this constitutionally, we considered not making the factual arguments at all. We considered saying, all right, we called on for workers to strike, whatever you said, but it's unconstitutional. We decided not to do it in the end because we thought it was a little bit too risky. So we asked the NLRB if they'd be willing to let us bifurcate the case, essentially do a motion to dismiss, which is not normal under board's procedures, so we could just attack the legal argument first, and if we lost on that, then fall back on the facts. They said we could not. They wouldn't let us bifurcate the case. So at that point, we asked them if they would send the case, we would respond fully, and if they would send the case to what's called the General Counsel's Division of Advice. Now, I don't want to get into board processes too much because that's not what this is about, but the Division of Advice took the case out of the region in Pittsburgh at our request and took it to DC. And the Division of Advice usually handles cases that are legally complex or novel, or where the General Counsel of the NLRB wants to make a legal change. So I wanted to get it in the hands of the Division of Advice because I wanted to make a legal change. We have a really progressive General Counsel of the board right now, and I thought that we had an opening, a possibility that he might take interest in the case and realize this is a good way to attack Section 8B4. So Advice did take the case, and unfortunately they gave us a decision which fortunately ordered the region to dismiss the charge, but unfortunately relied entirely on the facts of the case. It's like a 5-page decision, and the very last word in the decision has footnote 34. And footnote 34 says, the union also made a bunch of other legal arguments that we're not going to get to. So that was a little disappointing. But there's a glimmer of hope, because of course Sharad Hadid did not give up. They appealed the decision. And it's sitting right now at the Office of Appeals for the National Labor Relations Board General Counsel. And I've not seen their appeal yet, I've FOIA'd it, but I think it's probably pretty funny, based on their other arguments, that's my guess. But, so there is a slight chance that on appeal, the board will say, the Board's General Counsel will say, this is unconstitutional. I'm 99.9% sure they're just going to rely on what the Division of Advice said, because at the General Counsel's office, the Division of Advice is sort of considered the smartest folks in the room, so they're deferred to by everyone else. But we'll hear soon what's going on with the appeal, and hopefully before they get a decision, I'll be able to see what Sharad Hadid argued on appeal. So the case is almost certainly going to be dismissed, and we assume it'll be dismissed on factual grounds, not the First Amendment. So what did we accomplish, and why is this important? Well, first and foremost, we've beaten back a ridiculous attack on the unions and its members' ability to speak out on an important issue of the day. We will protect our members' rights. And slightly less important, but very important, we've now given space to other labor unions who may want to get involved in the BDS movement a template on how to legally do so. Okay, it's safe because the board said that this is not violating Section 8B4. I also think it's important that we've directly raised these constitutional issues with both the General Counsel's office at the board, at the National Labor Relations Board, and with our fellow labor unions. I know at least one example, a union that often is accused of secondary boycotts, and they have a lot of active cases. They've taken our argument and put it, our constitutional argument, and they're putting it in every one of their cases in the hopes to get a hearing on it. And although we think this case is about political speech, as I've said a couple times, we think that there's really good grounds to overturn Section 8B4 on, based on these right-wing expansion of the First Amendment. I'm not going to talk about it in detail, but there's another case, not just, it didn't get as much publicity as Citizens United. It's this case, Sorrell versus IMS Health. And in that case, they applied heightened judicial scrutiny, not strict scrutiny, but heightened scrutiny, to strike down a statute that regulated purely commercial speech because it was not speaker and content-based. And as we discussed before, Section 8B4 clearly is speaker-based. It only applies to unions, and it clearly discriminates based on the content of the union's speech. So at a minimum, even for non-political purposes, we would argue after this Sorrell case that Section 8B4 is subject to this heightened judicial scrutiny. We need to, in the labor movement, we need to continue this attack on the prohibition on secondary boycotts. The nature of the American workplace is changing, and it has changed. I mean, we have temp workers working alongside people who work with layer after layer after layer of subcontractors. Our fight is often not with the boss anymore. Our fight is really with whoever the boss's boss is. Whoever up the chain is making that decision. And the prohibition on secondary boycott prohibits us from taking on a fight with who our fight really is with. So if Citizens United and all these other corporate expansions of free speech give us an opening to attack Section 8B4, we absolutely have to.